I think the Collegium system has outlived its utility and is now decaying. The decay has to be stopped, and we can do that by overhauling our system. After all, we do want the judiciary to function appropriately, and we also want appointments to be made transparently and with some guideline and system to be there. What I notice is that the Supreme Court judge who is appointed from a particular high court runs his agenda of forcing the Chief Justice of that court to send names which he wants to be sent. And that is why the high courts are becoming absolutely spineless, because they are looking up at the Supreme Court for their appointments to the Supreme Court, for their appointment, for their transfers and the like. Therefore, I felt that it is an impropriety, and that appropriate selection is not taking place.
See, my take is very simple, and this has been said earlier. We are a constitutional democracy, and therefore the Constitution reigns supreme. What has to be remembered is that courts are the final interpreters of the Constitution. Now, the Constitution has been interpreted by the Supreme Court, and the Collegium system is a product of the interpretation of the Constitution by the Supreme Court. And since the court is the final interpreter of the Constitution, its interpretation must prevail. However much the government may not agree with that interpretation, but under our system, under our constitutional system, the Supreme Court being the final interpreter, its interpretation must be accepted. Therefore, my concern is that the state cannot say that it will not follow the judgment or the dicta laid down by the Supreme Court, because that creates a constitutional deadlock, and that is not healthy for any democracy. So therefore, in my view, once there is an interpretation of by the Supreme Court of the Constitution, unless that is altered or modified, and the state has ways and means to do it by applying to the Supreme Court, but unless that is done, so long as the judgment stands, courts being the final interpreters of the Constitution, that view must prevail and must be respected. So my response to that is that if the reports of the IB or the content of the report of the IB, firstly, I don't understand as to how the RAW would come in insofar as appointment of judges is concerned, but that's a bit of that's sidestepping the issue really. If it is the content of the IB report which is being used, which is the substratum of the objection of the state to the appointment of one other aspect of the matter, and that is what is sought to be used as a justification for saying that Parliament must have the last say in respect of appointment of judges. And there's also a reference by some constitutional functionaries to the basic structure doctrine, and a view has been expressed that doctrine is not perhaps correct, because Parliament is supreme, and this judgment of the Supreme Court impinges upon the supremacy of Parliament. Now, let me give you a few examples as to why I say that is not correct. There are certain very basic aspects in our Constitution. For example, adult suffrage, that every person above the age of 18 can vote. This is not even in the Fundamental Rights chapter. Now, suppose tomorrow the Parliament were to come up with a law or wanted to amend the Constitution to say adult suffrage will only be permitted in respects of persons over the age of 50. The argument will be the same, that Parliament is supreme and therefore the Supreme Court should not interfere. because this, even if it violates the basic structure, because this will violate democracy itself. Take, for example, tomorrow Parliament wanted to come up with a law which said that the term of each and every house of Parliament, shall be 20 years instead of 5. Doesn't that impinge upon our democratic structure? The same argument will be made that Parliament reigns supreme and therefore the court should not really interfere with any law made by Parliament on the ground that it violates basic structure. So the basic structure doctrine basically is a safeguard to constitutional democracy. And that is something that has to be appreciated. And this entire argument that the basic structure doctrine impedes upon supremacy of Parliament, in my view, is incorrect and is fallacious. The reports of the IB or the content of the report of the IB, firstly, I don't understand as to how the RAW would come in insofar as appointment of judges is concerned. But that's a bit of that's sidestepping the issue really. If it is the content of the IB report which is being used, which is the substratum of the objection of the state to the appointment of a particular person as a judge, on the one hand you talk about transparency. Now if the court without any reasons discards it, you will say that despite serious issues being raised by the IB, the court has recommended this particular person and therefore we are justified in resisting the appointment. So it's like damned if you do and damned if you don't. If reasons would not be given, one can argue that there is a sense of there is some kind of arbitrariness which pervades in the decision of the Collegium. If you give reasons, then you will say that these particular reasons impinge on secrecy or on some kind of security issues and therefore should not be given. So you can't have it both ways. If you want transparencies, if you want accountability, then surely reasons should be given. Therefore, I don't really agree with this criticism. Unless you can point out that in a particular case, a certain thing has a certain comment or some information directly impinges on national security. You see, national security can't be some kind of a carte blanche for the purposes of saying that national security pervades or national security is involved, and therefore without any reasons we can block any one person for a
whole controversy regarding to the collegium system. How do you see that, sir?
It is not between government and the collegium system, it is between the nation and the Supreme Court. Nation seems to be on one side, the entire country, and Supreme Court seems to be on one side. You see, the Supreme Court has to abide by the Constitution, and the collegium system being followed by the Supreme Court is unconstitutional. There is no provision in the Constitution about the collegium system. Even at the time of debates, when the issue of compulsory advice being binding on the Supreme Court was raised, this was discussed among the constitutional makers and they rejected it. They rejected that advice cannot be binding. It has only to be consultative process. And the finality will be of Supreme Court, of President choice. But the Supreme Court reversed this. I don't know how can Supreme Court go against the spirit of Constitution and the Constitution itself. If this issue had not been discussed, one could have understood that the Supreme Court was interpreting something which was not known. But this was very well known. This was known to the Supreme Constitution makers that this consultation process where the issue would arise, whether the consultation is binding or not. And this was threadbare discussed. I fail to understand how can Supreme Court reinterpret it contrary to the constitutional mandate and constitutional discussion.
So my second question to you would be the recent collegium resolution has revealed the IB and the raw report on which the law minister has also today reacted, saying that it's a serious issue. So what's your take on it, that, whether these kind of reports should be made public?
I think the Supreme Court should first make public the criteria of its selecting the people, merits, on what basis it considers that person is fit for being a judge. If the Supreme Court cannot reveal those criteria to the people, I don't know why Supreme Court has revealed IB report on this. All right, there is no harm in revealing this, but there is no harm in your selection criteria being revealed to the people. Why you are selecting out of lakhs of advocates available in this country, and at least several thousands in high courts and Supreme Court, one particular advocate that you which you like. The Supreme Court should first make it clear that what is the criteria of this knowing the eligibility, and see the examples are there. Not only examples, I say almost every appointment done by Supreme Court is meritless appointment. It is based only on the connections of the person.
Well, according to me, after the Supreme Court judgment striking down the NJC 4:1 on 16th of October 2015, the same bench sat again to decide that there are problems with the Collegium and that needs to be sorted out. And therefore, another judgment was rendered 2 months later, exactly on 16th of December 2015 by the very same 5 judges, wherein after taking suggestions from everyone and all, and the factum of asking for suggestions was put on the website of the Ministry of Law and Justice, some 15,000 suggestions were received, and Mr. Arvind Datar and Pinky Anand were asked to collate those suggestions. A judgment was given. That judgment, unfortunately, is not being followed today. That judgment required a secretariat to be made in every High Court and in the Supreme Court to lay down functions, duties and responsibilities therein. And then it talked of transparency, it talked of other things. So even those very judges who struck down the NJC felt that there is something required to be done for the Collegium. The only thing that we see today is that nothing has since happened. That their own, the court's decision, the Constitution bench decision, that should have been followed. So why the question is, if you make a secretariat, if you have a system in place where you can shortlist candidates and thereafter it goes to the Collegium for making a recommendation, it's a different thing. Today the perception is, I don't say that I agree with that perception, but the perception is that people who are known are the persons who are picked. And there are people who are unknown or may not be finding favor, but they are also as good and they have an aspiration, but they are not asked. 3rd of October 2017, if you go to the website on the Collegium resolutions, it is provided by the 5-judge Collegium of the Supreme Court that for bringing about transparency, each and every name recommended and put in will have a kind of a write-up as to why he or she is being recommended. Unfortunately or fortunately, another 5 judges in 2019 October said that we don't need to give the write-up about the candidates, and we will only give the names of who are being sent. So 2019, they themselves amended what they decided on October 17. So therefore, after all, therefore there is no transparency thereafter as to why a candidate is being chosen. It's only now when they've reiterated 4 names in the latest, the Collegium, in the latest resolution, they have given that what was the government's stand and what is their view and why they are reiterating. So this is a transparent process. But just sending names as to why they were chosen or how they were chosen, unless we see High Court resolutions, whether the High Court Collegium is sending reasons. Of course, I understand that the candidates are being interviewed, etc. But I am not sure about it. I have no personal knowledge or first-hand knowledge on this.